all those arguments that you've referenced today and the last time you were here, I'll give you that. I mean, I'll look at all the stuff you've got on the traveling argument, everything else, because what I told you earlier is I've got an open mind. Okay.
She told me that on the record in front of me. And all the things that she's saying, the judge said, she never said that. I have the record submitted.
So once again,
she wasn't doing this because the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again.
This right here is a crucial legal moment. The judge is drawing a hard line between arguing and appealing. In U.S. courts, once a judge rules, repeating the same argument doesn't move the needle. The only legal path forward is an appeal to a higher court. The defendant clearly believes persistence equals progress, but legally, that's not how the system works.
That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
I've been trying to get all this stuff established with the courts for years. And I still have evidence that I'm trying to get from the township that they're using lead codes to redact because they did with the policy information that I able and got them to give me the policy because they were trying to mess things up.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
This is rare.
Now watch closely. The judge perks up at the words new evidence. That's a potential game changer in any trial. But here's the catch. If you can't clearly explain what that evidence is, when you requested it, and why it matters, it stops being evidence, and starts sounding like confusion.
I haven't got it to even get to
No. Tell me what it is.
the evidence that I requested before is in the very beginning with my bottle camera.
No. But well, what is it? You're looking for some records, some ordinances? What?
Part of the traffic comments and things that were put in there. That
Hold on. In where?
in the comments.
You don't have police reports?
Well, I do, but I found out that they held certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents that are in the whole thing.
Hold on. Let me hear what she just said. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's bringing things from the southern notes and
You mean like the officer's personal notes? Had notes.
and for example, buying a camera where they're standing under a patrol car and the computer's on. Those are all lien material that can't be discoverable. It can't be shared with people outside those that are have the security clearance to observe or handle lien material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief that they purposely redacted out of the conversations and the notes that that are completely all redacted. It's nothing to do with computers and it's nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
I don't know that they withheld this when they should have given to me in the very beginning with my FOIA for everything that's involved in my traffic. So they didn't.
Okay, hold on. I'm trying to clarify. Are you talking about like, how do I want to say this? Personal comments between 2 or more individuals?
No, it's not personal comments. It's stuff that's logged through the traffic stop. Like,
No, stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
yeah.
Or edited the recording?
As well. And there was no clear reasons why. Every time I try to get reasons to why they did it or its connection because they're supposed to label why it is. I haven't got anything. And then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It's not the incident report. It was the while the traffic stop was taking place, stuff that was being entered through, like, I can't remember exactly what the paperwork is I am. Like I said, I'm in the process of getting it all. Having appealing to the supervisor, and that he didn't, he vaguely gave just cited statutes and codes, but he was supposed to tell me how and why I didn't see the applies to the lead sections, which are failing to do because saying
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected. Hold on. Is that a yes? That's what they're telling you?
Essentially.
This is where things get technical and dangerous for a self-represented defendant. He's mixing FOIA requests, line-protected data, and criminal discovery into one argument. Some of that information is legally restricted, no matter how unfair it feels. The judge is trying to translate chaos into something usable, and that's not easy.
Okay.
So, and I didn't part of the site they forgot from that. They didn't do it in any of the other ones. Only
Hold on. Other one what?
all of the because they're in several books. Several times the cops came out of their house. I think we were told, well, this has been going on for all of years. By incident.
Okay.
So I filed all of every cop that had been there, all the reports, anything to do with anything that I could get that was in access to me. And then that's how I found out that these other reports weren't released to me. And then in my life charts, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. But yeah, any of the other stuff is all open.
Redacted from,
The whole page is just black.
hold on, redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah.
Okay.
And there was no justification involved for why any of these things are redacted. I keep trying to, and then how they did this the policy. I tried to get the policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer is supposed to operate and stuff, right? So they denied several times stating the same lien codes are trying to fix all these connections now. So I appealed it to the township supervisor, and he released all of my information, and it showed that the policy showed that these officers violated the policy. And
Okay, hold on. Stop. So he released everything, but not everything you want?
well, then once I realized they were doing this, I went back to even more. That's how I found out there was more stuff that was under released to me.
Okay.
And then they're doing the same process using these lien codes to not let me see what was put in this hearing. And that's why it's all the American Titans. I've been trying and fighting all this full time trying to get this stuff together. And I'm getting every which way. I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As it is with this stop, he does have the incident report. He does have body on camera for 4 officers in our dash cam, what have you. He also personally took a video. I have it. There was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is the material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police came to his house or like a traffic stop or speeding ticket, there are no incident reports. Those are CAD. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had you diagram.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more now that I've been through the body cams. I have to file more to get more stuff unredacted because there is clear points in these conversations that will purposely redacted. They have nothing to do with any information that they keep claiming. Same thing with these cat sheets referring to. That's not what I'm trying to get hold of them. And I understand that there are things that they can redact through the lien codes. But these entire things that are, there's no way the entire pages and these comments and everything are all lead information. I know that. I've been told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and everything for retaliation against them. And I know for a fact what was said in these things. That's why I know it being redacted is more than much to say.
Okay. But Mr. Crisell, with all due respect, that all sounds like a civil lawsuit against the township.
Well, yeah, this is my argument. I've been trying to bring into this court, but everything's just being getting.
Because I'm not going to get into all that with a jury.
But it goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even got to this point.
I'm not going to let you get into all that with the jury. It's going to be confusing. We're going to go down rabbit holes.
That's why what's because I need to be able to present my case. Just fair.
So this case goes back to February. We set this trial 2 months ago.
You're right, but
2 months and 2 weeks.
Trying to get the jurisdiction status. I'm trying to get the judicial bias stuff taken care of. All of these things that have not, that they just keep. It is what it is. Being swept under the rug. But
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias.
This is a rare but powerful judicial moment. The judge flat out says, I know my own intent. In U.S. law, judicial bias isn't proven by disagreement, it's proven by evidence. And the judge makes it clear, if you believe bias exists, the remedy isn't arguing longer, it's appealing or filing a grievance.
Bias argument under the rug, I'm denying it.
without it, I give it, yes.
Okay. No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine. I guess that's something that I have already started to do a process. I will be going down it. The more I do it,
Okay.
So again,
Sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
yeah, like I said, I cannot participate in something that I know is stacked against 100%.
Well, once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
It shows that these things have to be established. That there has to be any.
Then
you see, bias like that. See, I mean,
okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham.
it has to be. And it's all this turned into.
Okay, bring the jury in. I'm tired of talking.
That sentence tells you everything. The court has hit its patience limit. From this point on, procedural debates are over. The system is moving forward whether the defendant feels ready or not. This is where many self-represented cases quietly unravel.
Motion who? Oh, I forgot you filed a motion. Give me just a moment. Yeah. Did you see that? Hold on. Did you get her motion?
I never seen that.
Yeah, no. You got a copy. You can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday, along with our
I have never seen this.
Take a minute to look at it.
Let's bring up for the record too.
Hold on. Hold on. Have you had a chance to look at what she just handed you? Okay. All right. So are you ready to argue that motion?
Well, no, I haven't no time to prepare for anything. I've never seen that before. And
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
These are facts to the case.
as you say.
And that's they're the same with the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
all part of this case.
Okay.
Same thing with all the way to the traffic stop, all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm trying to get all the matters. I'm not ready for that. So I've never even seen it, so I can't even build up a defense to that.
How was that provided to Mr. Crusoe last week? Okay.
His motion or his 109 motions on Thursday, so pretty much time to respond. I did send it in the mail. I dropped it off at the post office this morning. And I didn't receive his most recent motion.
That was filed Friday. Right.
I sent a letter to something else. I know it should in I mean, we've never got the first last name. Never.
All right. So here's what we're going to do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point on a point by point basis. Understood?
Yeah.
I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that. If you choose to present anything to the jury and one of these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
I filed for records of Weston's court, trying to get all my court hearings and everything in orders. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
These proceedings involved. I need to.
We should probably have Caitlin.
Yeah, she's coming.
All right, back on the record with the People versus Crusoe. All right, Mr. Crusoe, I just want to put on the record the conversation that we had out in the hallway with Mr. Bowditch present. Outside of your hearing, by the way. That's for that. But I filled you in. So you've agreed you're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury panel for being here today. Agreed? In exchange, we're going to pick a date, hopefully in the next 2 minutes. We're going to pick a date, put this back on our calendar down the road to give you plenty of chance to perfect your appeals, whatever you want to appeal. Agreed? Okay. All right. You can sit down. Okay. Now, but I have to say some other things. All right. Before I took the bench, I did a lot of court appointed work. All right. So I know that a lot of times when a defense attorney is talking to their client, they've got to get over a mental hurdle because a lot of people in a situation where the court's provided the attorney, they think the attorney's not working for them. The attorney's working for the court. So I want to make sure you understand how this works. Mr. Bowditch, although we've worked together for years, he doesn't work for me. Really, he doesn't even work at my pleasure. I suppose if all three judges in this court told the Michigan Indigent Defense Council Regional that he works for that we just don't want this guy in our courtroom anymore because he's just incompetent or whatever, they'd probably put him somewhere else. But other than something drastic like that, he's not here because I'm paying him and I've requested him. You understand that? Okay. His job, his client is MIDC. And I say his client because they pay him, but he's paid to represent folks in district court that don't have their own attorney. I just want to make sure you understand when he's giving you advice, he's not telling you what he thinks is best for me. He's telling you what he thinks is best for you. Okay. Now, the other thing, I'm assuming he brought my offer out to you. Listen, if you want to get into all those arguments that you've referenced today and the last time you were here, I'll give you that. I mean, I'll look at all the stuff you've got on the traveling argument, everything else, because what I told you earlier is I've got an open mind. Okay.
This explanation is gold. The judge dismantles a common myth. Court-appointed lawyers don't work for the judge, and they don't work against the defendant. Their loyalty is to the client. When defendants don't trust their own counsel, strategy collapses, and courts see this pattern all the time.
I don't think in my heart of hearts you can convince me that your argument on traveling is a valid one, but I'll listen to everything you've got to tell me on that and every other issue. I mean, I'll give you an entire day set aside for a trial to do all that, but not with a jury. All right. So I want you to know that's an option. I'd like, and if you need to have some conversation with your family or Mr. Bowditch, I'd like a decision on that today, because when you walk out here, I'd like to have a date on the calendar for either a bench trial or a jury trial. Okay. And I hope, based on my earlier conversations, you understand why I can be much more free and easy about what I let in when it's just me making the decisions than it is with a bunch of jurors. All right. Bowditch, go ahead.
Could we actually adjourn this? Now, Priscilla and I have had a conversation. I think we can streamline this case quite a bit. Could we set another motion date? It's nothing that's been covered. We covered new ground.
Okay.
It should be a simple motion with his understanding. It's yes or no. And then if we need to proceed to a bench trial, we would.
How far down the road?
Well, it depends on how long his the discovery is going to take. If there's anything even possible to be retrieved, but I still
Probably a month is too tight.
Well, I know that's in the process. I've already appealed to the conference. No, I'm in the process.
Okay. Hold on. I think so. October 21 is too tight, I think. October 21, I think, is too tight. Time frame wise, you want to go into the next month?
We can, Your Honor. It's up to the courts.
I have no idea how that process is going to work, so I don't know.
Yeah, I mean, I'm more time.
With what the court's done today and asking more favors.
No, you're not asking a favor. We're just scheduling a date.
Do you do
What is it?
that's a Monday before Tuesday?
Yeah, that was
We'll
it.
open that day.
Gotta be so.
If Caitlin is
Do you have an opening on Monday the 25th? You're not scheduled.
of November.
Just for a motion. This is just a motion hearing. We're not going to take testimony. Okay.
As long as you're not no
Don't-
you don't have them that month last night.
So that'll work.
What's the date?
9 a.m. the 25th of November. It's the Monday before Thanksgiving. Nobody's got travel plans?
Motion date.
Okay. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day.
Yes, Your Honor. Or we'll resolve
Okay. All right.
it.
Okay. I didn't ask. Can you pay the $300 today? Okay. And I implore you, keep talking to him. Keep talking to him. All right. Anything else? All right. We're adjourned. Yeah, go ahead.
Officers are here and you guys are ready to testify.
Understood. And you can give them my apologies. Put it all on me. So your civil infractions, we're just kicking those down the road. Understood? Okay. Or I keep saying infractions. It's 2 misdemeanors, 1 civil infraction. All right. Okay. So everything's adjourned. I'll make a note in the file so the cashier knows what to do with your $300.
Mr. Bowditch on as your
Not officially, I don't think.
let me just give you notice.
Did we set that at 8:30 or 9?
You said no.
9? We set it at 9, but if he's always here early, she'll probably be here early. So get here early. We might get it done with. You're not late if you're not here before 9, but just telling you. Okay. We'll get your notice. You're good to go.
You're on cashier, right?
Yeah, I got money. You got to do something.
Thank you, Your Honor.
Thank you, Mr. Bowditch. I appreciate the efforts. All right. Caitlin, enjoy your Monday.
Yeah, thanks.
A routine hearing explodes into a tense clash as the defendant accuses the court of bias, constitutional violations, and suppressed evidence. The judge pushes back hard, repeating one key point: disagreement is not bias, and denied motions can't be argued forever without proper appeals. As tempers rise, the judge explains the risks of self-representation, threatens contempt, and draws strict limits on what a jury is allowed to hear. In the end, instead of forcing the trial forward, the judge postpones proceedings, sets a new motion date, and gives the defendant time to appeal and regroup. Order is restored, but the conflict is far from over. Was the judge maintaining fairness, or shutting down a defendant who challenged the system?